People should, if they think something is discriminatory, if they think something is a veiled discrimination, they should call it out. They should bring it up. They should consider becoming plaintiffs or challenging those programs and policies. But let's just start with being brave enough to call it out and say, this is wrong. You should not treat people differently based on race, even if you believe that your goal is a noble one and that there should be racial mixing. It's not right to require one person to work harder than someone else to get the same damn result.
Welcome to The Wild Show with your hosts, Will Chang, Lee Cheng, and Andrew Su. Hi, this is Will Cheng, and as always, I have my co-hosts Lee Cheng and Andrew Su with me.
Hey, guys. Hey, great to be here.
Today we have our friend Lee Cheng with an E. Lee is an attorney and civil rights activist who has fought discrimination against Asian Americans for 3 decades. Lee helped found the Asian American Legal Foundation and the Asian American Coalition for Education, most well known for its part in helping win the Students for Fair Admissions versus Harvard, a landmark decision of the Supreme Court in 2023 in which the court held that race-based affirmative action programs in college admission processes violate the Equal Protection Clause of the 14th Amendment. As the chief legal officer for Newegg, Lee was famously known as the chief troll hunter. He was one of the few attorneys a decade ago to fight back against the multi-billion-dollar patent troll industry and win. Lee is a 2-time winner of the National Law Journal's America's 50 Outstanding General Counsel and numerous other awards for innovation and excellence in the practice of law. Lee is currently a shareholder of Galter Law Firm, where he's a member of the Corporate, Intellectual Property, and Litigation Practice Groups and the chair of the Greater China Practice Group. Welcome, Lee.
Thank you, Will. And hi, Andrew, and hi, myself. Very, very glad to be here, and I appreciate the opportunity.
I feel like to get a sense of who you are, I first thought we should get started on Newegg. What was Newegg and why were you known as the chief troll hunter?
That was one of the nicer nicknames for me at Newegg. I acquired that nickname somewhat unwillingly. I wasn't looking for it when I joined Newegg as the general counsel in 2005. I was a corporate lawyer originally by training, and if anybody knows anything about the practice of corporate law, people who chose that specialty are people who don't like litigation. We want to stay far away from litigation. And if we do our jobs right, we will never see the inside of a courtroom. So when I joined Newegg, Newegg was an internet retailer. At one time, it was the second largest internet retailer in the United States after only Amazon. And we were also at one time the second largest in China. And I wasn't expecting to find lawsuits hitting my desk where people were claiming that we infringed their patents because Newegg was a retailer. We didn't make anything. And so to my great surprise, lawsuits started landing on my desk that claimed that we owed a fantastic amount of money, millions of dollars, because the holders of certain patents claimed that they owned the rights to the online shopping cart. And I wasn't an intellectual property specialist. I certainly wasn't an engineer. And I just looked at it and I said, this just doesn't make any sense. It seems to be completely absurd. And I started digging in to this type of litigation and this type of claim. And I quickly found out that these were basically extortion lawsuits. People have a mythology in America about patents. And the mythology basically suggests that every patent is the fruit of this incredible spark of genius from this little inventor sitting inside a lab. This inventor creates something incredibly valuable and deserves a windfall. And that's just not true. I mean, every year, about 300,000 patents get burped out of the USPTO simply because people hired a lawyer to translate an idea into legalese. And if you hire a lawyer, you will basically get a patent. About 80% of all patent applications eventually get allowed. And the vast, vast majority will never see the inside of a product. It will not be used to make anything that benefits humanity. But every one of these patents can then be used. There's a presumption of validity to extort money. And some of these are written very, very broadly. And because the cost of defending against a lawsuit is so high, literally hundreds of thousands of dollars or millions of dollars, most people find it cost effective to settle. So that's what was happening. People were just settling these lawsuits, not because the patent claims were actually valid, but it cost too much to try to invalidate them or defend themselves and establish that they didn't infringe. So I looked at this and I said, look, we're the second largest internet retailer. Everything that Amazon at the time was getting sued on, we would get sued on. And Amazon had paid this particular troll, Sovereign Software, who claimed to own the online shopping cart, $40 million. And we didn't have $40 million. We couldn't afford to pay them off the way Amazon did. So I had to develop a strategy to fight patent trolling, to fight this type of extortionary litigation, or else our company would have been in very, very bad shape. We would have gone out of business. So that's what I did. I came up with a way to manage the cost of litigation. We used boutique law firms. And I also really came to deeply feel, I can talk a little bit more about why I've tilted at the windmills I've tilted at in my career. I came to deeply feel that it was just the right thing to do. And we had to fight these extortionary cases and show that they could be fought, so that other people would start standing up and pushing back on these legal extortionists. And so they would stop hurting smaller companies and ultimately the American consumer. So I became known as a troll slayer because we fought back and tried to fight back intelligently. And over time, we won. So out of the 35 claims filed against Newegg during my tenure, my 11-year tenure at Newegg, we never lost. And we went to trial 3 times in East Texas. Our strategy was actually not to avoid trial. Our strategy was to get through trial in the notoriously plaintiff-friendly venue of East Texas so that we could get up on appeal, where the judges were generally far more fair in terms of applying law and rational in terms of applying law, and the appellate court judges. And on appeal, we never lost. So eventually people just stopped suing us. I mean, put a number of trolls out of business. And we developed a number of techniques, I think, that were very, very useful in the last wave of extortionary patent litigation.
Could you describe what the patent troll industry was like and why 40% of all patent infringement claims were brought through Eastern District of Texas?
Sure. So the patent troll phenomenon in the industry is just the group of plaintiff lawyers and plaintiffs who decided to use patents as a vehicle to extort money using our notoriously loose litigation system. We have a very unique legal system in the world. It's not surprisingly called the American system. One of the attributes of the American legal system is the fact that we don't have losers paying. People who file lawsuits in the United States, unless they, under extremely egregious circumstances, under very rare circumstances, will not have to pay if they lose. And so the belief is well-intentioned, which is that we want to encourage people to seek justice and not to discourage the small guy or person from seeking justice because of the threat of loss. But unfortunately, the actual effect is that it creates a huge wave of extortionary litigation because there's no negative consequences to filing frivolous lawsuits. And so we have millions and millions of lawyers in America who look for loopholes and areas in the law that allow them to just dump a claim in the court system and just point out, sometimes quite literally and smirking, that, hey, you know the cost of defense is going to be more than what I'm asking you for. So just pay up. And they get away with it sometimes for years and decades on these schemes. So patent litigation is just one of the flavors and one of the more, in my opinion, harmful to the American economy because of its impact on innovation and entrepreneurs, flavors of extortionary litigation.
What do you evaluate when you determine in these circumstances whether or not to fight? I think with Newegg, you've done the analysis up front, but I'm curious, what analysis did you do or would you do now?
I'm in private practice now. So I represent many different clients in many different industries with different types of businesses. Don't get me wrong. I'm not anti-intellectual property. I'm not anti-patent. I think there's a place for patents. I think patents have value. I don't think patents automatically deserve a windfall. I'm actually the named inventor on 4 patents myself. I just don't happen to think that grant of a patent by itself without really any effort to commercialize should entitle anyone to a windfall. My perspective is it's different now because I represent many different types of clients, and not all clients have the ability to defend themselves the way that Newegg defended itself. And not all clients had the unique sort of business model that Newegg had. Newegg was a retailer. We didn't manufacture anything. We had a website that anybody who sold products online essentially had, all the basic functionalities. Now, we probably tended to code more than of our own functionalities than most websites. We had more resources to do it. If someone sends a demand letter or a lawsuit hit my desk, what you would evaluate first is, in my opinion, I go straight to the end. What is a fair amount of damages that should be owed to the extent that there's even a valid patent? Second of all, I think, what are the prospects that this is actually a valid patent claim and that my client actually infringes? So it doesn't make a lot of sense to me. It's very not cost effective to do what a lot of big law firms automatically do, which is they send technically trained lawyers in, junior lawyers in, to do a deep dive on whether a client infringes on claims that ends up costing tens of thousands of dollars of analysis. And then they write a memo that articulates the possible damages if a client is found to be willfully infringing. It's pretty scary. It's one of the things that drives a lot of clients to settle. The reality is that, again, in the vast majority of instances, in my opinion, especially when asserted on the consumer side, the patents asserted are garbage, and especially by non-practicing entities. If someone's getting sued by a competitor, I think usually you need to take a little bit, you look at who is asserting the patent. If it's by a non-practice entity, it's probably not a very high quality patent. You have to assess, in my shoes now for the client, is this a tactical or strategic problem? Is this the first time that this client's been hit by a patent claim, or is it the third time or the fourth time? If it's the first time, speaking very candidly, it just doesn't make sense to spend the deep 5 or 6 figures in defense costs it would take, at least, deterred this plaintiff from pursuing the case by developing it and fighting back. If someone's been targeted serially and they have developed a reputation for being an easy target and they start to catch 3 or 4 lawsuits or more, they need to fight back because the settlement costs start to add up and more people will start to sue them. I'll give you an example. Way back in what I call the second golden age of patent trolling, some companies developed this reputation for settling everything, like Victoria's Secret. So Victoria's Secret was sued because they had a successful website. And if I remember correctly, there was a point in time, there was a record that they'd settled like 39 lawsuits in a row. They became the target for everybody. And so eventually, when we showed by fighting back against Sovereign Software, the shopping cart troll, that it could be done, they decided to fight back too, which is a smart thing to do. Except, unfortunately, they caught a jury that awarded something like $10 million in fees against them and damages against them when they finally chose to dig down and fight. But we ended up doing them a little bit of a favor by invalidating all the patents on appeal. So somebody at Victoria's Secret ended up purchasing a lunch from me. I would have preferred a ticket to the Angels show, but I was very glad to have the free lunch for saving them $10 million. But, it happens. So my advice is right now, you have to evaluate the situation. If it's the first time that they've been sued, my advice is to try to negotiate the best possible settlement deal and be done with it and hope that it doesn't become a serial problem. Unfortunately, this being the United States, one of the signs of success an organization has become successful is that they start catching lawsuits, extortion lawsuits. And so as companies get bigger and more successful and they get higher profile, they inevitably attract the attention of some negative attention, like from patent trolls.
Quick question, Lee. So it sounds like, and again, commend you for what you did with Newegg, but in terms of the current landscape, is the system still inherently broken in the sense that this is still happening? Is the current landscape different in any way? Or is this just something that, to your point, you just have to balance and figure out when to fight back like you did?
The system's broken. We managed to roll the trolls back somewhat. I managed to do it for Newegg when I was chief legal officer. People stopped suing us because there are just too many easy targets out there. But I always recognize that the real reform that needs to occur that will really, really, really deter extortionists is reform around the law of damages. What damages are available if infringement is found? If people do not get windfalls or do not have the possibility of getting massive windfalls based upon simply owning or purchasing a patent that's never been used in a product or service that benefited anyone, then there would be no incentive to file these frivolous lawsuits. So again, there's this mythology that every patent is somehow the basis for and contributes to world-changing products. That's not true. Most of the time, people make products and services and entrepreneurs create successful businesses. So even companies with tens of thousands of patents like Google and Facebook, Apple and Amazon, right? They didn't really start building their portfolio until after they succeeded, and they did it for defensive purposes so that they could cross-license them with other large companies with big portfolios. None of them succeeded by asserting their patents against anyone. They succeeded by making good products and delivering good services.
Let me ask you one question. You've mentioned before that lawyers don't take risks. And that's the reason why Amazon and Gap were sued for millions of dollars. You've also mentioned that the new executives were Chinese American. Do you mind just telling us why you decided to take a stand for Newegg and fight back in a way that nobody else, no other lawyer at the time, was fighting back?
I need to qualify what I said about lawyers not liking to take risks. Some lawyers do take risks. Plaintiffs' lawyers who work on contingency obviously are risk takers. But most lawyers at big law firms, and then most lawyers who go in-house, are inherently significantly risk averse. In my opinion, risk aversion is one of the draws. It's one of the characteristics of vast majority of people who decide to attend law school. Because those who graduate from law school, I think they believe that they can make a fairly good living simply because they have a JD. So it tends to draw people who are generally very risk averse, who believe that risk management means risk elimination or risk avoidance, which is really the wrong attitude to have if you're trying to win. If you're too afraid to lose, in many instances, you can't win. And so in the in-house world, that's actually probably more true because people who go in-house, in most instances, people who have worked in private practice for a number of years, and then they are willing to trade generally lower salaries for steadier hours in a less complex environment than private practice. So why did I decide to fight back? I've always wanted to do the right thing. I've always tried to do the right thing. So we'll probably talk about my work in civil rights in a while and what motivated that. And my initial instinct, again, was this type of activity was just wrong. It was extortion. The claimants, sovereign, they added no value to us. We derived no benefit from them. These were people who set up a toll booth on a public road and demanded that everyone walking down this public road had to pay them money because somehow they were allowed to set up this toll booth by some careless governmental agency called the USPTO. And they wanted a huge amount of money. I knew how hard our founders had worked to build Newegg up. I knew what actual risks they took in order to make Newegg successful. It had nothing to do with the online shopping cart. Any number of thousands of online retailers used an online shopping cart and didn't succeed. So the online shopping cart really nothing to do with our success or our revenues or our royalties, even to the extent that something that obvious could be patented, was appropriately patented. And just instinctively, it's a joke that the USPTO burped that thing out. Like I said, something like 80% of all patents that end up getting filed eventually get allowed if someone pays enough money to lawyers to translate ideas into legalese. The average sort of amount of time that an examiner at the USPTO spends on reviewing a patent before allowance is 10 hours. It's really not that much time to examine records and files to see if there is prior art, blah, 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 if the patents are actually novel, blah, blah, blah. So it's just one of these situations where people were able to continue to be able to take advantage of mythologies that they've created, loopholes that exist in our legal system, deficiencies and defects, and the very high cost of defensive litigation. It's very hard when anyone gets sued for anything, even if it's a completely bogus and frivolous lawsuit, to actually get dismissed. It would take thousands of dollars. And so why did I decide to do this? Again, it started with I just thought it was wrong. I recognized a strategic risk to Newegg. We could not, because we were number 2 to Amazon, we could not afford to just follow in Amazon's footsteps and settle the way Amazon settled. We literally would have gone out of business if we had to pay what Amazon paid. So I recognized the strategic implications, and then I was able to build a business case to fight. And part of it was financial. So, for example, the trolls at the time were demanding low 7 figures, millions of dollars to settle. That was the going rate. And the rule of thumb at the time for legal defense costs for a patent suit, the claim count was somewhere between $3 and $6 million. At $6 million, that's kind of high, but I went, instead of hiring big law firms, the giant behemoth law firms like Latham or Cooley or Weil Gotshal, I went and hired boutique law firms. I had to spend more time managing them, frankly. But their bill rates were much lower, and they were very appreciative of the work. And so because I used those resources and also a lot of internal Newegg resources, we were able to basically control our defense costs to around $3.5 million spread over 5 years. So if you calculate the time value of the money, I mean, pay $2.5 million up front and $3.5 million over 5 years, it made sense then to defend ourselves. But I also looked at the law. I actually looked at the law before I looked at anything else, and I looked at it from the top down. What did the Supreme Court say? What did the Court of Appeals say? The Federal Circuit Court of Appeals, which is the relevant Court of Appeals. It was very clear to me at the highest level of the American judiciary. They understood what needed to be done. They understood that if they allowed patent trolling to prevail, the American economy would crater. So all the decisions that made it up the appellate level tended to be in favor of defendants. So I knew if I could break these cases up into the Court of Appeals, I had a very, very good chance of winning. So instead of fearing the Eastern District of Texas's notorious so-called rocket docket, they tried to scare people by saying, well, we'll move you to trial really fast. You're only going to have 5 days to try your case. I said, that's great. 5 days, great, because it limits my defense costs. Every day that you have to show up in court, you have to show up with a bunch of lawyers. Time. So 5 days, that's wonderful. We need to get through, and we need to basically make sure that if there's a damages award against us, because East Texas was notoriously plaintiff friendly, the award would be below what I reserved. That accounting becomes part of the game too, and it's probably a little bit more complicated than we can cover on this call. And so the roll of the dice was simply to get through trial with a damages award. We could even afford to lose in East Texas, but we just needed a damages award below our reserve. And that's what happened. So we got a jury award against us for $2.5 million. Our side of the table was smiling. Their side of the table was very sad. As it turned out, the plaintiffs in the case, they had asked for $34 million. So my risk was if the jury had gone crazy and awarded them $34 million, it would have been overturned on appeal, but potentially I would have lost my job. So that was my risk. And my strong feeling was that I shouldn't be afraid to lose my job to do the best job I could. I owed it to my company and my shareholders to assume some of that risk to get the best possible result rather than take the easy path. So those who are risk averse in-house, they can just point to everyone else and say, hey, everyone else settled. I'm only doing what everyone else did. It's nice and safe, right? So I have not minded taking risk onto myself in order to achieve a better than average result. Because if you just do what the herd does, the best you can achieve is what the herd can achieve, the average member of the herd can achieve, but generally you're probably eating a lot of shit.
This is amazing. And I felt like this is such a big part of your story. I want to understand why you became a lawyer in the first place.
Well, that was an accident. So I did not intend on being a lawyer because my father spent a lot of time making fun of lawyers. So when I got into college, my father, like probably not a small number of Asian parents, he actually sat me down. When I got into Harvard, he said, Lee, now that you've gotten into college, I'd like you to consider what profession you're going to enter. So my father was a librarian. And he said, you don't have to choose right away, but here are your 4 options: accountant, architect, engineer, and doctor. Those were my 4 options. He said, you don't have to choose right away, but let me know next week. And lawyer was not one of the 4 choices. And actually, I really hadn't thought about it. Even though I'd always liked public policy and I was on the debate team, lawyer was just not one of my choices because my father was always making dumb lawyer jokes. So I really suffered because I was not very good at math or science. Kind of broke the Asian stereotype and mold there. I could tolerate it. I could manage to not fail the courses, but it was very miserable. So I was pre-med for 3 years. And very fortunately, on May 4th of 1992, just as I was about to take the MCATs, I sat up in my bed. I literally had an epiphany and I said, I'm not going to medical school. I just did not want to go to medical school and I felt it very strongly. And then I thought about, well, what do I like? And I did like the idea of being able to make a difference through law. I remembered actually, so this actually will segue into my work in civil rights. So I remember being very outraged by what I saw when I was applying to a public high school, Lowell High School in San Francisco in 1984, when I found out, much to my shock and dismay, that if you were specifically Chinese American, you had to get a higher score on the academic admissions index than applicants of any other ethnic group. And this was being done allegedly to serve a great public cause, and it was supposed to be desegregation or something like that. And it didn't matter if the Chinese kid was rich or poor. And the kids who were hurt the worst were the poor Chinese kids because they had a harder time jumping the higher hurdles that the middle class and the kids from wealthier families could jump. And so I had a friend who was my stand partner in orchestra. but for being the fact that he was Chinese, he would have gotten into Lowell if he had been any other ethnic group but Chinese. And that made me very angry and sad. It was clear to me that Chinese Americans didn't have any advantages. We weren't given any advantages by the system. We'd never discriminated against anybody in America. This was all being done because of some Harvard asshole's theory that I'm not making this up. His name's Gary Orfield. And there's never any accountability for these guys when they come up with these theories and these bogus studies where he claimed that Black students couldn't learn properly and couldn't succeed in class unless they were in a racially mixed environment. Okay. And it didn't matter that they experimented with this type of educational integration for 20 years and the test scores for Black students kept going down. I mean, there was just no cost of failure for this guy, but the price of his experimentation was really being borne by Chinese American kids. And so I never forgot what happened. So I actually did some research when I was in college about racial preference. Was it legal? No, it's not legal. Wait a second, then how come no one's challenged it? Well, because even back then, the Asian American civil rights establishment, so what passes for Asian American civil rights groups, they were always walking lockstep because their funding was always from the same sources as the NAACP. So they never wanted to antagonize or contradict the NAACP. They did not stand up for Asian Americans. So parents and kids being discriminated against in San Francisco would be approach groups like Chinese for Affirmative Action and say, hey, look, this seems so unfair. Can you help us? And they would be told by these Chinese and Asian American civil rights groups, oh, there's nothing wrong here. In fact, this is glorious. You're just being selfish. You shouldn't want your kids to go to the best high schools or best colleges anyway. You should be open-minded. And it's like, excuse me, why should Chinese Americans uniquely not be able to aspire to any opportunities available to anyone else? It's just completely bogus. So they were actually discouraged from doing anything by the Asian American civil rights groups. And then it just really came down to nobody wanted to do it. Nobody wanted to take time out of their busy days. Nobody wanted to sort of detract from their career advancement at big law firms to do it. And so I realized that there was no reason people couldn't challenge the quota system in the San Francisco Unified School District. And I also realized that Asian Americans had a very, very unique role to play in advancing civil rights in the United States, because many of the arguments that could be used against white plaintiffs in these cases, one of the arguments, which I disagree with vehemently, is that it's okay to discriminate against white people because white people of the past were slave owners. I mean, that's just utter bullshit. This is America, and the sins of the father should not be visited upon the children or the grandchildren. There's no white person today who owned any slaves and discriminated against Asian Americans in Chinatown or intern Japanese Americans. But that was a common argument. Reverse discrimination is kind of okay. And that argument could not be used against Asian American plaintiffs. So I realized that we had a very important role to potentially play in civil rights jurisprudence in challenging racial preference programs because they, in fact, hurt us. So what was the way to challenge it? What was the best mechanism? It was an individual lawsuit. So some of the research I did when I was in college suggested that there were some Asian American families that had challenged admissions into the UCs, flagship UC schools, Cal and UCLA. And they ended up never actually progressing to suit because the UCs would cleverly just admit the students whose family challenged. And that, together with a Supreme Court case called DeFunis v. Odegaard, caused me to realize that these legal challenges should not use individual plaintiffs because they would be too easy to buy out, to moot. And so when we eventually organized what became known as the Ho versus San Francisco Unified School District lawsuit, I proposed using the class action vehicle to prosecute these discrimination claims. The benefit of the class action claim is that you can't moot it once the class is certified. The problem with the class action claim is that it takes many years sometimes just to get a class certified. So that lawsuit, which we started filing in 1994, we were very fortunate to find pro bono lawyers, Dan Gerard of Gerard and Green in San Francisco. But that lawsuit ended up taking 6 years to sort of get to even the point where we were about to start a trial. It took a couple of years to work through the class certification issues. But eventually, when we were on the courthouse steps about to begin trial, the national NAACP realized that they did not want our case to go up to the Supreme Court because they knew what it would look like if poor Asian kids were being denied admissions to kindergarten and to high school and to middle school under some sort of backdoor racial preference program, showed up in front of the Supreme Court. Their whole corrupt racial preference edifice would have collapsed very quickly, 20 years earlier than it actually did. So the national NAACP ordered the local NAACP and SFUSD, the San Francisco Unified School District, to settle with us. They gave us everything we wanted. No more quotas. They paid all of our lawyer fees. It was a deal we couldn't turn down, but it turned out to be a very Pyrrhic victory because we didn't set a higher level precedent with that case. We ended up with some very bad Supreme Court precedents in 2003 and 2015 that set the cause of Asian American and civil rights and individual rights back until the SFFA versus Harvard case last year.
Just to give the audience a timeline, you started law school in Berkeley after Harvard in 1994, and the Ho versus San Francisco Unified School District case started in 1984. So you pretty much already on this path while you're going to law school. Is that correct?
Right. I took a year off between college and law school. So I deferred law school for a year, and during that year, I helped organize the Ho versus SFUSD lawsuit. So I found a group in San Francisco, the Chinese American Democratic Club, that had already tried for several years to mitigate the quotas through the political system. They tried to negotiate an appeal to the superintendent of schools in San Francisco, to the Board of Education in San Francisco, and at best they were very politely blown off. And then at worst they were called selfish Chinese people for wanting nothing more than basic equal opportunity and rights. And so I managed to hook up with CADC in the fall of 1993. Because I was outside looking in, it was very apparent to me that they weren't going to make any progress at all through the political system. Asian Americans were disrespected by the political establishment in San Francisco back in 93, 94, even more. They're disrespected now. When you look at political power in San Francisco, California, to the extent that there are Asian Americans who hold any power, it's really, in my opinion, substantial tokenism. San Francisco is 30% Asian American. You certainly wouldn't know it by looking at the people occupying the mayor's office, the board of supervisors, and who occupies and who holds all of the most powerful administrative offices in San Francisco. I mean, that's just the way it worked then. It's a little bit better now. I pointed out to my friends and colleagues in CADC that as commendable as their efforts to effect change politically were, it probably wouldn't work. And so we started pursuing the path that powerless minorities have always used, which is for redress, which is the judicial path.
Ho versus San Francisco Unified School District won by stopping San Francisco public school systems from imposing racial quotas, especially against Chinese Americans. And that fight really lasted for another 30 years before Students for Fair Admissions versus Harvard. I read a bit of your amicus brief. Could you talk about your amicus brief and what you wrote in it?
Did you have a nice nap after you read it? No. So that was an amicus brief that we started filing in the mid-late 90s. So we were the first Asian American civil rights group, the Asian American Legal Foundation, which was formed to help organize the Ho litigation. Subsequently, we were the first Asian American civil rights group, and for many years, the only Asian American civil rights group to articulate a position that Asian Americans should never be discriminated against for any reason, no matter who it benefited. We were the first group to take that position. And what we pointed out was there's a long history. So an amicus brief means friend of the court. Amicus curiae, friend of the court. It is not intended to substitute for the party's brief, right? In a lawsuit, they're supposed to make their case. The amici are supposed to bring to the court issues, facts, observations that are supposed to help the court make its decision by providing more context. What we tried to do was to provide historical context. Asian Americans, since Asians first came to America, have been on the wrong side of discrimination, always. It's highly ironic that, once again, Asian Americans are getting screwed now in the name of racial justice. There is no difference between discrimination for good intentions and discrimination not for good intentions. Basically, we're getting screwed. And we also highlighted the parallels between what was happening to Asian Americans in school admissions and what happened to Jewish Americans starting in the 1920s onwards in Ivy League admissions. And we tried to explain why racial preferences are so wrong, what the practical implications are, the harm that they cause to Asian American kids who are impacted and families who are impacted. And then eventually our amicus briefs started to point out what harms the stereotyping caused by essentially lumping Asian Americans as together with white people as all uniformly privileged, by stereotyping Asian Americans. It was actually, and by in some instances, claiming that the discrimination, the preferences, anti-Asian preferences were justified because Asian Americans were allegedly privileged and Asians got, quote unquote, more than our fair share. The advocates, the supporters of preferences were contributing to anti-Asian violence. Absolutely. We've all heard people say, hey, you want it all, you're selfish, yada, 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 that kind of crap. That's what we tried to do in our amicus briefs, and we were very consistent. And so starting probably about 2008, a few groups started to join our briefs, other Asian American groups. And then in the 2010s, we started partnering with a coalition called the Asian American Coalition for Education. So we write the briefs, but they tap into their national network of hundreds and hundreds of Asian American groups around the country to become signatories to this brief so that significant part of our community can speak, and have their voices heard. And over time, many of the arguments that we've made, so I've been a co-author on that brief for some time, and I tended to steer the language into a direction that was, I think, a little more blunt and to swing for the fences. We were one of the first groups to ask the Supreme Court to consider overturning the Grutter decision of 2003 because the implications of Grutter were just so horrible. Grutter basically said, unelected bureaucrat or military officer declares that without needing to submit any evidence that using race to set policy was a compelling state interest, the courts had to give deference, which is actually extremely dangerous. If you think about how internment of Japanese Americans was supported, it was because a bunch of racist generals claimed that Japanese Americans on the West Coast were national security risks. They didn't really have any proof. The deference afforded to these unelected bureaucrats to be allowed to use race without being subjected to the traditional Supreme Court standard of strict scrutiny, very strict scrutiny. That was something that we wanted to make sure was and will be opposed. We want high standards before the government is able to use race to treat Americans of different ethnic groups differently.
Thanks for explaining that. So as the coalitions were joining with the amicus brief that you'd created, how did the brief and kind of the movement progress to ultimately being heard in court?
The briefs are not really heard in court. So the parties each submit their brief, pro, con, and the amici will submit their briefs. They have to submit their brief a certain number of days after the parties submit their briefs. And the Supreme Court clerks who will typically read the briefs. They read the briefs. And for people who write amicus briefs, it's always considered a huge, huge success and honor if your brief gets mentioned or quoted in any of the Supreme Court decisions. So our brief has actually been quoted in the 2015 dissent in the Fisher case and in the SFFA case in one of the concurrences, overturning the Harvard admissions program. But at this point in my life, in my career, and also my colleagues, guys, I have to tell you, time flies. I remember meeting with one of my colleagues in the Asian American Legal Foundation, Roland Kwan, back in 1994, like it was yesterday. He came to my house and we started chatting about what CADC was doing to fight the consent decree. And time flies. 30 years has just gone by. We really honestly just don't care about getting credit. It's very rewarding to see many of the concepts that we articulated. We believe we articulated first and consistently for many years, getting picked up in other amicus briefs, being adopted in the Supreme Court decision. The result was reached. Whether or not we get credit for it, it really just doesn't matter. We wanted to make sure that that message kept getting across, and that also that Asian Americans do care about, or at least certainly some of us do care about our rights, about the rights of our children, about the rights of our friends and FF brothers.
For the people who do care and are pushing towards a specific case or ruling, besides, I guess, signing on or signing an amicus brief, what are other avenues where they can contribute to either new cases or ongoing cases?
Well, I think to the extent anyone sees instances. So right now, after SFFA, The good news is the Supreme Court ruled against racial preference. The bad news is that that doesn't mean that schools will not try to find ways and loopholes around the SFFA decision. It's a misconception that a Supreme Court decision, even a very, very wise and good one, ends the evil that it seeks to end. So I'll give you an example. Brown versus Board of Education, 1954. Segregation did not end in 1954. There was decades of litigation because segregationists, people who are committed to a certain ideology, in that case, the ideology of segregation, with the fervor of religion, religious belief, they spent decades trying to figure out ways to circumvent Brown, to be able to segregate legally. They were using proxies. So instead of using race, they would say stuff like maybe zip codes, whether your grandfather voted, stuff like that. And they would just use proxies to try to discriminate, to try to segregate. And not surprisingly, people who support racial preference. It's one of the pillars of the modern religion known as DEI, the cult known as DEI. They didn't want to give up. And DEI also is a multi-billion-dollar industry. They don't want to give that up easily. And so even before the Harvard decision was rendered, there were plans on how to use proxies to circumvent an adverse ruling. So just as an example right now, there are schools that are using zip codes. They'll target zip codes like Thomas Jefferson. They'll target zip codes where there are very few Asians, right? Technically, they're not using race. But at this point, the Supreme Court has decided this year not to hear the TJ case and to let proxies be tested for some period of time. So what can be done? People should, if they think something is discriminatory, if they think something is a veiled discrimination, they should call it out. They should bring it up. They should consider becoming plaintiffs or challenging those programs and policies. But let's just start with being brave enough to call it out and say, this is wrong. You should not treat people differently based on race, even if you believe that your goal is a noble one and that there should be racial mixing. It's not right to require one person to work harder than someone else to get the same damn result. And in American society, for probably the last 10, 15 years, a lot of people have a lot of bad things become normalized and slide by because they were afraid to be criticized or canceled. A lot of Asian Americans, we do fairly well in our academic careers and our professional careers, and we don't want to make waves. We don't want to upset the generally good path that we're on. So we just let a lot of these bad things slide by. If you're at your office and you hear that there's a position or promotions that are not available to people based on race, to Asian Americans based on race, you should call it out. You should report it. You should blow the damn whistle. Will someone retaliate against you? Maybe, but push back because the laws are in place to protect you. And if we don't avail ourselves of those laws, the situation is going to just get worse and worse until there's no longer an ability to challenge the unfairness. That's how people can help. People can, at an individual level, simply just speak up, encourage other people to speak up. And you can advocate and lobby your local representative, elected officials. You can consider running for office, but just don't stay silent.
This is an amazing landmark ruling. And obviously we covered a bit of that, but are there any next steps that perhaps you and your coalition or other interest groups are looking at right now? And then on the topic of broader racial discrimination, Chinese American issues, what you're looking at and thoughts around that?
Well, we need to make sure that it has meaning. Yeah, so that means that we need to make sure it's enforced. A lot of the people who favor racial preferences, like I said, they're not just going to give up, especially in situations where there's money involved, DEI consulting gigs, yada, yada, who are asked to help shape admissions policies, blah, blah. So we need to make sure that that decision is implemented by challenging racial preference programs everywhere we see them. I think the Asian American Legal Foundation, we're going to continue to encourage people to consider becoming plaintiffs, to report what they see. I think we're going to continue to support all of the plaintiffs in cases that are challenging proxies, the use of racial proxies. We are going to file an amicus brief in a case involving Boston Latin sometime this month. So we're preparing to file an amicus brief. It's a proxy case, and we're prepared to continue to do that and to make our voice known. And that's a situation where it really would be a tragedy if the Supreme Court did not accelerate decision making on banning proxies. It took them literally decades to essentially tie up and close off one proxy after another in the segregation context. And we know it's coming. We can see some of the proxies being implemented now and being tested and being articulated as tests now. And it's understandable that the Supreme Court may not want to invite attack and controversy in consecutive years with controversial racial cases. But it would be truly tragic, and I think that potentially a dereliction of their duty if they keep punting proxy cases, because if they do that, it will simply prolong the ability to cause for these proxies to be used to cause harm to thousands or millions of individuals, including Asian American kids. So yeah, we were going to keep fighting. We're going to keep pushing because we've recognized for a long time that as important as this landmark decision, and this decision, in my view, stands right up there with Brown. It reaffirms Brown and pulls equal protection jurisprudence back to the heights that were being eroded by decisions like Bakke and by decisions like the Fisher decision in 2015. The Grutter decision was probably one of the worst Supreme Court decisions in, I think, history. It was very unprincipled and ranked against other negative precedents in equal protection jurisprudence. In my opinion, it's actually the second worst next to only behind Dred Scott. Dred Scott basically said it's okay, Black people and non-white people are inferior. Plessy v. Ferguson, although reviled, Plessy v. Ferguson actually said separate but equal. But there's at least an implication that there had to be equality. And then, of course, the pinnacle was Brown. And then we started eroding out of Brown. And so SFFA reestablished has taken our country's equal protection jurisprudence back to the right levels.
One of the things that stood out to me as I've been doing the prep work is that you've been on this fight for the last 30 years. And I personally, for the longest time until very recently, felt like anti-affirmative action was racist. And I'm sure Asian Americans generally, affirmative action is quite polarizing. And I think sentiment has been shifting now to really understanding what affirmative action is. For a really long time, I think even the mention of being anti-affirmative action would cause a lot of racist remarks or things like that. And you've been able to fight through this entire time. How have you been able to really stand up for what you believe in, continually fight for this cause?
Because I know what's true. Because I saw the effect firsthand of, it's very important to not just use these euphemisms and catchphrases blindly, because that's exactly what the racist advocates of racial preference want. Just think about how horrifying and disgusting what they did is. They euphemized racism. I don't oppose affirmative action. Who's stupid enough to oppose action that is affirmative? By definition, then you must favor negative action. So what's being opposed is not affirmative action. What's being opposed is racial preference, the use of determinate racial preference. What's affirmative about that? That's like calling evil good. The advocates of racial preference very cleverly managed to convince most people that racial preference and affirmative action were one and the same, which is not true at all. Affirmative action did not end with SFFA. Affirmative action was never challenged. Never challenged. Prop 209 did not end affirmative action. People can consider any factor. In fact, under Prop 209, people could even consider race. It just had to be considered as one of many equal factors, not the determinant factor, not the significant factor. So just think about what is at the heart, the definition of racism. It's the determinant or significant use of race to view or treat individuals differently than other individuals, and generally in negative ways. That's the heart of racism. And that actually also is racial preference. And it doesn't matter what your intention is, but that's still racism. So you were misled, Will. You know, many Asian Americans were misled. And why did people wake up? Because they started thinking about it. And the other part of it is, just speaking candidly, people started to become personally impacted. There's an old saying, a conservative is a liberal who's been mugged. And a person who wakes up from the lie of affirmative action of racial preference is oftentimes a person who has seen the impact. It's just like in San Francisco, for example, or other large cities. You have many people who are walking around, oh, we love restorative justice. We're against a carceral state. We want equity in criminal justice. We can't imprison someone if they are non-white because there are too many non-whites in prison. And then they get mugged. And the sad part is that the reality is the vast majority of crimes committed by non-white criminals are against members of their own ethnic group. The release of tens of thousands of felons has hurt which community the worst? There's no question, it's the Black community. Not putting murderers in jail and keeping them there. Who does it hurt the most? It hurts the Black community the most because 78% of Black murder victims are killed by Black murderers. That's a fact. All of the feel-good and good intentions that people use to get others, again, out of good intentions, to adopt irrational policies and laws. Eventually, they meet something called reality. And so I don't know. I've always believed that there is a right and there's a wrong. I've tried to be very practical about it. I've tried to be consistent about it. And yeah, people have attacked me. And, you know, it's okay. It's okay. Everyone's entitled to their point of view. They're not entitled to their own fact, and I try to use the fact.
Moving on to a different topic, you're the current chair of Greater China Practice Group for your law firm. You recently went to China and Taiwan, and I wanted to get your feel for how you feel about what's going on with China and Taiwan right now.
Obviously, I think everyone acknowledges now that there is tension. It's not something that surprises me. So it actually ties to my fight for civil rights. Many, many years ago, starting in the 90s, actually, I started to believe that it was very important to fight for equal protection standard where Asian Americans are treated equally, adamantly equally, because I was very concerned as a student of history looking at what happened to Japanese Americans in World War II, that the inevitable rivalry that I saw eventually developing between the United States and China, even as early as 1990, the Soviet Union went down. China was not quite ready to challenge American hegemony, but it's obvious that China would. And my concern was eventually if there was a rivalry that people of ethnic Chinese descent in America, we would end up in the same place as Japanese Americans did in World War II. And that's still a possibility to this day because the reality is that civilization is like a veneer. You scratch it hard enough. What's underneath is not really, it's just base human nature. It's about survival. So at least if we had the right legal standard, we would have some level of protection as opposed to none whatsoever, right? So my fears are being realized, I think, because despite optimism in the early years of what now has been acknowledged as Pax Americana. So we're very fortunate that we got to live in an era where America, or the country that we happen to live in, was the undisputed global hegemon, the most powerful nation in the world that no one could challenge for probably about 20 to 25 years. Our passport could open any door. We were welcomed everywhere. Our living standards kept going up. But I think we are very clearly not beyond the outside of the cycles of history. And so we now have not just one other power vying for hegemonic position, but multiple other powers. Russia is reasserting itself. India is starting to become more powerful as their political system is reorganizing around a strong and forceful leader. Even countries like Iran and Turkey, some of the countries in the Middle East, I mean, we're just not dominant anymore. So in that context, China, Taiwan, first of all, it was a great trip. I saw a lot of the FF brothers. Great to see everybody. It is very important, I think, to see people in person because people are generally far more willing to share candidly and offer their opinions in person than they are certainly over mediums like WeChat and even email. And so I learned a lot. There's concern on both sides of the strait. There are people, a lot of people, taking measures. They're making contingency plans to have rights, residency rights, relocation rights outside of Taiwan and outside of China. In China, it's quite popular for people of high net worth to establish family offices, for example, in Singapore. So there's concern. There's a lot of hope. Everyone is really hopeful that the leaders that in America we elect and the leader that China has selected not make any sort of rash decisions in the short term, and that there will be a focus instead on trying to continue to elevate the prosperity levels of the citizens of our respective nations. There continues to be a tremendous amount of mutual benefit that our nations can derive from cross-border trade. We appear to be getting more Chinese manufactured products into America than ever, despite the fact that in China are both trying to right now decouple in terms of their technology standards and their manufacturing capabilities. Taiwan occupies a very unique position. It's a very well-deserved, hard-earned position as a place where critical technologies and technology products are manufactured. There really isn't anyone right now, for example, and it's largely centered around the semiconductor industry and around one company, TSMC. Nobody can touch the TSMC yields. That said, very, very obviously, I think everyone knows that China is investing heavily in TSMC circumventions and workarounds. And China has already managed to develop some pretty sophisticated products using technology, semiconductor technologies that are not the most cutting edge. And so over time, I think it's very clear that China will wean itself of its dependency. So right now, Taiwan supplies probably something like 80 to 90% of all the most sophisticated chips that go into tech products, even in China. So I think over time, there's a realization that China is not going to be that dependent. There's no reason for China to attack Taiwan, practical reason, but there certainly is a political reason. So people are very concerned. No one that I met wants war. No one. Everyone wants us to all just get along.
I really respect your work, and I really respect your ability to fight for what you think is right, regardless what other people think of you. I just really appreciate you sitting down with us and explaining everything that you've done.
Thank you, Will. And I appreciate your having me and giving me this opportunity to hopefully satisfactorily address some questions and also just share my thoughts with your audience.
Thank you.
Thank you, Will.
Thank you so much for listening until the end. If you've enjoyed this episode, please leave us a review on Spotify or Apple Podcasts. It'll help more people like you find us. You can find more about us on wild.show, wld.show. Please subscribe to our newsletter or DM us on Twitter. We'd love to get to know you.